everybody. Welcome back to the Law and Crime Network. I am Michael Bryant, and I'll be with you for the afternoon session here with Imran Ansari. He's going to be joining me for a regular plethora of things. Did you enjoy your break, whether it be Easter or Passover? I've got the leftover Easter tie on here. Was going to wear the bonnet, but thought, maybe a bit much. Well, I mean, it's just mind-boggling. Imran, you have these kids making these statements. They're adults now, almost alibying for the parents, saying, we get it, we understand, they did the best they could, not sounding like, they really messed us up for life. What's your reaction to that?
I think it's an insight into the actual sort of scarred and fractured emotional and psychological well-being of these children. You just have to imagine how their mindset is at this point. They've been stunted both emotionally, psychologically, and even physically. So I think all these things have a play in these statements. They also were compartmentalized, basically shut off from the rest of the world. So the parents were really the only individuals they knew for their well-being, their caretaking. And of course, we know that caretaking fell far below reasonable standards here to a criminal point. I think it's an interesting insight into the mind of, say, a victim, perhaps a little Stockholm syndrome there, but it was very compelling. You heard statements from a number of the children, which range in age, I think, from 29 down to toddlers. So it's really, really compelling.
I mean, it is codependence at its worst. I mean, these are kids that, as much as they may have hated it, didn't really know how bad it was because they had no point of reference. But here they are saying, these are our parents, we love them and they're doing the best they can, It truly is crazy to think that they came out of this, and at least from that statement, and I've heard some of the others who actually voiced their opinions in court, they sound like they're doing okay, that they've gotten help, they're rationalizing, and they're moving on with their lives, which is the most important thing, right?
Right, and we know that some of them, I think one or two of them are actually in college now, so there's maybe some redemption here. Obviously, these children are going to be, dealing with this for the rest of their lives, the emotional scars of their childhood. But we know, I believe there was one child, Joshua, he's in college right now, he's getting his bachelor's, he's looking to get his master's. So there is some hope and redemption for these children out of this sort of scarred background. But again, it's going to be something they're going to be dealing with both emotionally, psychologically, and physically for the rest of their lives.
What I thought was very interesting was this dichotomy of the abuse the parents were dumping on these kids, but also the faith and religion. So now the faith and religion that they've been brought up with has helped them tolerate what happened and rise above it. So it's just a fascinating case study. Wow. Louise Turpin there. You also heard from David Turpin, the parents who now are on their way to life sentences for the torture and false imprisonment of all their children. Let me ask you first, Imran Ansari is here. The demeanor of the parents, relatively. The mom is weepy. She was crying during one or two of the victim impact statements. Dad, pretty stoic, pretty matter of fact. We know that it's believed, based on what the kids have said, that it was Dad that kind of was the instigator. Mom went along with it somehow, and these kids feel like they escaped him making them go along with this whole plan as well. So what's your take on their demeanor and whether that supports that analysis or not?
Right. Well, yeah, you see that the father is a little more stoic. I know there was at one point in the beginning of his statement, which we didn't see in this clip right now, where he did get choked up. He asked his attorney to start reading the statement. There was at one point during that read where he felt there was something that she was leaving out. He took the statement back and then proceeded to give the statement himself in that rather stoic manner, not very apologetic. At all. There's no really conceding the fact that he's put his kids through this. There's a recognition on his behalf that he's optimistic for their future. And then you see the mother. She, is very weepy throughout the whole process of the victim impact statement. She's crying. But again, it doesn't seem to be any apology. They took responsibility for the actions by taking that plea, but you don't really see an outright apology for the way they treated these kids.
It's not like they're saying, we were wrong, that was really not the way to go. They're almost like, well, we got caught, and you may not agree with what we've done, and we're going to pay the price for that.
Right, I agree. There's certain ways and certain conduct a person has to really live up to under the law. I think that the Turpins had their own interpretation of what was right, what was lawful. Perhaps it was religious based in some respect in their minds, or the way they followed their faith, and that didn't fly under the law. So I don't know if they really accept responsibility, that they have created a house of horrors, if you will, for these children. Because you didn't really see any real concessions or any real taking of responsibility within their statements.
And I'll tell you what, I think they made the judge's job very easy, because if they had been more contrite, more apologetic, boy, we just did such horrible thing, it might have been, more difficult to give them a life sentence. Easy the way they reacted.
Right.
Okay, thank you, Imran. We're going to get back to Imran and some other analysis as we move through the cases we're discussing this afternoon. Imran Ansari, defense attorney, trial attorney, is with me. I think the prosecution's got huge problems in this case. I think there's a lot of reasonable doubt, and give me your take on this.
Right. Reasonable doubt, reasonable doubt, reasonable doubt. That's what I would be saying if I was McStay's attorney during my summation, and pointing out to all the different factors and different points of reasonable doubt that the jury could consider in this case.
Let's hit the high points. What do you think are the three biggest problems in this case?
There's the lack of forensics, right? There's a lack of forensics both on the actual financial side, which conclusively places this crime on Merritt. There's the sort of bungles at the crime scene in terms of preserving evidence. We just heard Aaron discussing the splatter on that table, which could or could not be blood, right? That wasn't preserved. Then there's the DNA evidence, which sort of inconclusively also, again, does not link Merritt to this crime. Then there's Dan Kavanaugh, right? That's the
I only said three. Oh.
Right.
Yes,
I'm going on
right.
and on and on. But,
right.
Dan Kavanaugh, I think, is a big factor in the reasonable doubt angle here, and I think the defense right now on their case is really looking to point that finger at that mysterious Dan Kavanaugh in this case.
And the most recent testimony, again, the defense is putting on their case, the most recent testimony has suggested that maybe Dan Kavanaugh was not in Hawaii when this crime took place, February 4, 2010. Maybe some of the tracing they used through his PayPal account and others puts him closer to Southern California when this happened. There's an airline ticket that they couldn't, apparently there's no manifest. I don't understand that. I don't understand how the prosecution doesn't have a manifest that shows whether he did or did not get on that plane. This is 2010. It's not like before 9/11, where things were a little more wild and you could get on a plane with somebody else's ticket.
Right.
Not anymore. So that's huge to me. What do you think is going on with the proof of travel?
Do we have anyone who's coming into court and saying, listen, I saw Dan Kavanaugh in Hawaii at that time, at those critical moments? There is no one, right? So you have, again, this circumstantial evidence that Dan Kavanaugh was in Hawaii at the time, this alibi information for Dan Kavanaugh, but none of it is conclusively laid out there in court. I think what the prosecution needs is someone to say, yes, Dan Kavanaugh was with me in Hawaii, or have that manifest showing that Dan Kavanaugh boarded that plane, went to Hawaii, and he was in Hawaii at the time of these murders.
If he was there as long as the prosecution suggests, you should have a ton of witnesses, that said, yeah, he was at this bar, we went to this beach, we went, you've seen Dan Kavanaugh, he's kind of a dude, I'm sure he's surfing or something over there. There's got to be a ton of people that they could find that saw this guy, some evidence he was actually there, and then once you've proved he was there, make sure it covers the time frame that you need. I don't know. I think that's a huge problem. I have kind of a crazy theory about this case. That would be that Dan Kavanaugh worked with Charles Merritt to dispose of the business partner that maybe wasn't seeing things their way. Okay? So now they come up with an alibi for Dan Kavanaugh to take him out of the prosecutor's crosshairs. Prosecution gets the guy who really didn't do it, and they don't even have the evidence to convict him. But they've already taken their sights off Dan Kavanaugh, and they can't get a conviction to get Merritt. It's like the perfect crime. Am I just loopy, or is that possible?
That would be it would be a mastermind, sort of criminal mastermind scenario there, but let's just adopt your theory. If that's the case and Merritt is acquitted, how do you go back now and place Kavanaugh under arrest and go forward with the trial against Kavanaugh?
It'd be a joke.
It'd
be a joke.
Exactly.
You would be, so you're sure you got the right guy this time, right? That would be the public and the defense perception. Okay, well, we're not going to figure that out just today, But the court is going to be back in session this afternoon. As soon as they finish their break, we will join them out in San Bernardino, California for the McStay murder family case. We have some breaking news for you out of Jupiter, Florida. When you hear Jupiter, Florida, you automatically think Robert Kraft, and that is what this relates to. You know that he's fighting the release of a videotape allegedly showing him in a compromising position at a day spa there. He is facing charges related to prostitution in that case. Well, now, nearly 36 men and women have filed a federal class action lawsuit claiming that Florida authorities unlawfully videotaped them as they received legal massages at the Jupiter Day Spa. So that is a case that's going to roll along while the other plays out, the criminal case plays out. But they center around a nucleus of similar facts, and that is, did authorities have the legal right to videotape customers inside that spa, whether they were targeted customers, as it appears Robert Kraft might have been, or just folks in there to get a massage with no other hanky-panky. So this is brand new. This has just been filed. 31 John and Jane Does have alleged that the prosecutors and the Jupiter Police Department violated their rights to privacy by videotaping them, quote, without their knowledge or consent, end quote. And that is at the Orchids of Asia Day Spa there. This all taking place back in January. So also of note here, and Imran Ansari is with me to talk about this, also of note is that this week, we believe, is the hearing brought by Robert Kraft to suppress the tape in his criminal case, but based on the same grounds, that the authorities did not have the legal right to videotape him. And we always thought, when he first said, I'm pleading not guilty, and he didn't take a deal, that there was something going on, because if a videotape existed, how could he just plead not guilty? Well, we know now. He thinks the tape was illegal. He wants to keep it out, right?
Right, because, you know, if they succeed, meaning they, Robert Kraft's defense team, succeed in suppressing this videotape, well, the prosecution's case just got that much harder. So what they're going to be doing is they're going to be looking to suppress this videotape on constitutional grounds, invasion of privacy. Here in New York, we call that a MAP hearing. That's to suppress physical evidence from being introduced at trial. Physical evidence would also include a video of this nature. So now you have this federal class action suit, which is filed on a parallel ground as the state criminal case. Often when there's a civil case, whether it be federal or state, and there's a pending state action, which is a criminal action, that civil action may be stayed pending the outcome of the criminal case. So although it's filed, there may be components of it which may be stayed. We don't expect necessarily Robert Kraft to be sitting for a deposition on that civil case while the criminal case is pending. I'm sure his criminal attorneys would not allow that to happen. But if they succeed in suppressing the videotape, then they have suppressed key evidence against Kraft. They're going to be probably attacking the search warrant, the warrant which allowed them to install those cameras in that day spa, and we're going to have to see what happens at that suppression hearing.
Yeah, and the result of that hearing and the criminal action could make the civil action moot. It could decide all of the proper issues, and you really don't need to go forward with the civil case. You can rely collaterally on what happened in the criminal case.
That's correct. So a federal judge would have an opportunity to really adopt the findings, take a judicial adoption of the findings in the criminal case, and apply that as the theory or the case of the law of the case, rather, in the federal case. And then if that issue is decided in the criminal case, it really makes the civil case all the more stronger. They finding that the privacy was, violated, that this video was taken in violation of Kraft and the other plaintiffs' constitutional rights, and then they're going to be talking about damages, what they are entitled to based on this violation of their constitutional rights.
Right, so a little collateral estoppel and res judicata. I always like to throw that out there whenever I can. You know, my professors from way back will go, oh, good, he was listening that day.
And any attorney knows that res judicata and collateral estoppel is a very effective tool in the courtroom.
It's powerful, and especially in a situation like this where you might have a criminal case preceding a civil action. Right. Very good. What are we gonna do now? Kamana, I'm talking to him. We're gonna do Merritt. Thank you, Kamana. We were busy talking, and I kind of forgot where we were going there. Okay. Randolph Beasley now, he is under cross-examination. This is the defense expert who's talking about what he would expect to find at the scene of these brutal murders. Now the prosecution is crossing to say, hey, have you done this experiment? What did you do with this one? Imran Ansari is here. I don't know that that's answering the ultimate question, which is, if these murders took place in that house, it'd be a mess. Why didn't we find that mess in there?
Right. So now the prosecution is trying to sort of poke holes in the methodology of this expert's experimentation. trying to cast it as being flawed in some respect, and that the testing was not up to par, perhaps, to definitively sort of explain away the defense sort of theory in terms of this murder happening in this home or not happening in this home, and the lack of forensic evidence, the lack of blood splatter on the walls there. So the defense is trying to poke holes into it, but again, like you said, all right, there's 4 people murdered here, 2 adults, 2 children with a mallet, a hand mallet. You would expect the scene to be a gruesome mess and definitively hard to clean up.
Yeah, so I appreciate his attacking the methodology, but if I'm in the jury, I'm sitting there saying, okay, so there's less blood, there was no blood found, really. Just those little spatters on that table didn't seem to really be definitive if you're trying to prove they took place in the house. What do you expect to happen here? This case is almost over. Quickly, what do you think is going to happen in this case? Okay,
so I think that the defense is going to wrap up their case. There's going to be a lot of marshaling of evidence because it's been such a long trial.
Guilty or not guilty?
You know what? My opinion, not guilty.
Okay, we'll see how it goes. They are wrapping things up. I'm going to wrap things up for today here at the Law and Crime Network. Stand by for Aaron Keller. The Daily Debrief is on the way. If you want to jump back into the Merritt case, go to lawandcrime.com and get the dedicated feed there. So thank you for joining me. Hope you had a great weekend. Have a nice evening. I'll see you next time right here on Law and Crime. Good night.